okayfm 101.7.
Lawyer Kwame Adofo, private legal practitioner. You didn't ntwetwe enkomo efa nsem bi ehuhiam ewo emeremu. Law, council me moache.
As a voice no watch kakra o.
Council
yes kakra.
Mate pa. We dia akwa se akwa bi Jesus sa na yare. Na wati n'anim ano, ohun se nipa. Was wo nipa se nnua. Ne sa yi. Law, and when you mammy favorite Supreme Court 4-1 decision, a woman de buy if I were Kevin Taylor, the other court down one more a far ni warrant to want some arrest warrant to want some. It will say a dear banana if we are sebeche.
Kwame Mamin Chief for ne or for ne or more. Union Mono studio in a movie action. Look, 4-1 split. Just a judges in Ankara, they disagreed among themselves. Yes. They disagreed among themselves because are unanimous. That's it.
Okay.
4-1. No. This will be a test. Ruling Nankasa is a test for law students. They will be reading it and they will tell us why the one judge did not agree with the others. And it means that Wohano as commentators. Yes, so likely we are going to disagree.
Now, my law, Mammy Musadli, dear Metia woman say decision no majority of the Apex Court of the Land, the Supreme Court judges, no, Ejina Swan say, necessary a man of quine, a man, Kayetina Sam, Ewo, and San Bia, ye committing to contempt or ya man arrest warrant, no near the idea. Benny Pes or my, why not? Ye man arrest warrant, I guess ye TN one's an arrest warrant.
And only no, and even themselves, the judges disagree. You see, no, it means say, no court can order a warrant to arrest anybody anymore. Since answer was no. It means say bench warrant now. While my court issue for you to be brought to court is now being rendered nugatory and also useless. Because the position of the law, they say bench warrant. Who if you read the act, the court act near dinner, and the act now. The court can issue bench warrants when you don't come to court. It means that come to court, come and tell us why you are not guilty of X, Y, Z.
Summons should be a criminal summons should be a come and show cause.
Yes. So there's nothing wrong with say we are issue warrants for you to be arrested. It doesn't mean you are guilty of any offense. See, you are convicting. See, this is the distinction. Then it makes sense why you did not hear him before you convicted him. The man has not been convicted. The court wants him to come and then show cause why he should not be convicted for contempt. It's a warrant issue day to day against everybody or anybody who fails to come to court. And they say police officer in a court no asking for bench warrant. It means that the court now cannot grant it.
Oh, sanity.
Was it?
But it will be a dangerous precedent.
It is dangerous. I don't think the judges now they could not agree. The judges themselves could not agree because some of you said, for you to come to court and you say you are not coming, the only remedy available to the court is to issue a warrant for you to be brought. Which is what has to be done. Otherwise, you are not coming. It is issue warrant. It doesn't mean that you are guilty of any offense. The court has not said Kevin Taylor is guilty of any offense at all. What the court did, they say, was say a certain video has been brought to the court's attention of somebody insulting the court, and therefore produce him before the court to answer. That's the underlying word, to answer to the question of why he should not be committed for contempt. That is what we call police natural justice and alternative party. The court.
Law, Mr. Kuta, a Criminal Other Offences Act procedure no 1960. Now, what kind section 71 now? Well, it was the issue of warrant of arrest. A warrant may be issued at any time before or after the time appointed in the summons for appearance of the accused, although a summons may have been issued.
Exactly.
Now, two no swap or say a warrant shall not be issued under subsection 1 unless a complaint or charge has been made on oath. Now, over 72 no was a summons disobeyed, where the accused does not appear at the time and place appointed in and by the summons, and the accused personal attendance has not been dispensed with under Article 70, the court may issue a warrant to arrest the accused and cause the accused to be brought to before court.
See, in a way, no, the court has now made Act 30 that provision already.
Act 30, yeah.
Useless. But you see, courts are not, they are subservient to Act of Parliament. The law is made by lawmakers, and courts interpret the law. That is the position of the law. In interpreting the law, no, it's almost say he needed to be given a hearing before a bench warrant is issued. Meaning that it's a police officer court. Not say, oh yeah, officer here a year. And so back, many people who know. But when you're not hearing before you get bench warrant. Meanwhile, if you look at this warrant, that's an issue here, or Koko Kwasi and right. What's it? Bring him, he has to be produced before the court to answer. That's what we call natural justice. Audi or terror party rule now. After was it, come and answer. So, the judge got it wrong. He hasn't convicted Kevin Taylor. So this is going to be a very fierce debate among law students.
Because they say no, we'll be to be in court to see a issue arrest warrant.
Because now the judge, the Supreme Court is giving him a hearing first. Keep him no.
And I just so confused.
How do you give him a hearing? I don't think the judges know themselves; they could not agree. That's why I went for one. Because how do you give somebody who is on the run a hearing first?
Now, Attorney General no betumi akọ review. Meanwhile, say no ankọ nso amba.
Attorney General was the interested party. You see, he was served with the processes. As an interested party, he ought to have gone and argued against it. Oh yeah, another one.
I said no one to me. I'm calling saying
it means that what by ambassador you are free, you are above the law.
Na me ba cho me bo say ama case na substantive case no ankasa na na ese oba na ye betie na no asem no aye moot ana say again.
It's moot. Now he is no longer required to go to any court.
Oh wow.
To answer anything. Because the warrant has now been struck out. It means that now there's nothing for him to go and answer. Nobody is asking for him anymore. Because you see the practicality of this, and I say it's impossible for you to give somebody a hearing before you should issue a warrant for his arrest. How do you give him a hearing before you issue a warrant for his arrest?
I see.
What did they make?
Me patcho meet you.
And also, it's an act of parliament.
Yeah, an act of parliament, yes, sure.
Yes. Hey, where the person fails to come to court, issue a warrant. And the police for any warrant, or all police warrants will now be set aside. It means that now, can operator, the warrant has to be set aside.
Ah! Anybody bet me a use way? But yes, case be so adjudicated on its own merit.
Matter. When the Supreme Court speaks, they set the law. they have now set the law. Say, for you to even issue a warrant, you need to give the person a hearing. That's what it means. If the OSP warrant no issue, it means that it's now a nullity because he hasn't given Oforiaka a hearing. It is as well judgment. No.
Wow.
Master, we are in for a big storm.
Wow.
All warrants issued before yesterday are now going to be questioned because you did not give the person a hearing. Now, how is that practicable? The practicality of it is that it's not possible for you to give somebody a hearing before you issue a warrant for his arrest. It's your jubilating now, they don't know it's as well. It's a police officer to be mama and a because there's a whole fugitive now, there's no hearing and a court are granted. That is what will happen.
Eti obi betimi arane to the Supreme Court. Ebra ye issue arrest warrant the amano say man hearing answer.
That's what it means. Of course, our authority original so. It original so at the Supreme Court, depending on the panel, we decide to set this ruling aside as wrong.
Okay.
Supreme Court can change its ruling anytime.
Right.
So what is the mechanism?
Me too, pa.
So the another bench will say no, we got it wrong with this ruling. We are setting aside. Otherwise, now it means that no police officer can go to court and apply for bench warrant. Because if it's granted, it means that it's a nullity because you did not give the person a hearing. That's what it means.
And Act 30 no so a procedure a kwanya has offer so.
Asem no me my yes be my year cases are police officers arrested my client, put him in prison, police cells for 13 days. I sued the police and I quoted this act, and the judge agreed with me. Hey, the purpose of bench warrant is not to go and arrest the person and put the person in prison. No, you arrest him and bring him to the court immediately. It's all that warrant against Kevin Taylor was supposed to do is that he was supposed to arrested, brought before a court, and the court will discharge it. See, it is there second no back room has 2nd July to say obey. Almost trouble airport. No, the court, not court to discharge it. Bench warrant. There was no need for even Supreme Court to them to take this case to the Supreme Court.
Okay.
What did they make?
Me too, pa.
Because bench warrant, it doesn't say put him in prison. No. It just says bring him before the court.
Oh, okay.
That's all it means.
Yes, yes, kwachin kotum debi.
Debi. Arrest him and bring him, produce him. It's not a commotion airport. Maybe I'm here. That is here. Academy at Chino Airport. They had the court. The court are granting the bail. Finish. There was no need to go to Supreme Court. They say what is the Supreme Court is changing the whole position of the law now. Meaning that now ordinary bench warrants issued to police officers is now a nullity.
Wow.
Yes, and so the Supreme Court better answer position.
I see. Na been more hani abo mo wanted ne bia. You do pictures about days in the no.
And the man catch say can operate a case, Now it means it's a nullity. Because the warrant was issued to these people without hearing from Ken Operator. Kevin Taylor's case has now changed the position of the law.
Okay. All right. Now, Lord, Mammy Samra, and so another landmark a year by any say, Dr. Kwame Adofo and 7 others, so no, Jai Womu, na issue near Sikabia, na a year of my dear, a could do Womu. Aha. Sikabia, a could do Womu, na yes, Womu, and she says, Womu 60%. And a man who can see Jawomu. Plea bargaining acts, no. Say a kafa sadi any dia is no.
Nana, there is no law in Ghana that says who 60% to be down. There's no law. What the Attorney General was saying is a lot of crap.
Why?
There's one court to law. The law, no position of the law, say, even under the Court Act, you can enter into an agreement with the prosecution to provide compensation in lieu of going to prison. But you have to be convicted first. Aha. It means to say, so we are Abansika, another through certain circumstances, Abansika becomes a financial losser. You can enter into an agreement and say, oh, I'll pay X. And if it's acceptable to the state, the state is okay, pay X, but you have to be convicted. It's not available to somebody who is not prepared to be convicted. I don't know.
Yeah.
He agreed to pay a certain amount, which was accepted. It's more like terms of settlement. But if you fail, it means that you have to. So Ato Essien was convicted first, and he was given an opportunity to pay. Failing to pay, then you go to prison.
Okay.
That is what ended Ato Essien in prison.
Oh, okay.
There's no law. And I was quite reading it. I was really quite curious to see which law he was going to cite. Once I did law,
one court authority,
one guy, one court to read. Would they pay you know kind of
Mati.
And one say we're 60% and it's blah blah blah.
Let's say you can't put something on nothing. So in absence of any law like that, you know, you then not come by that 60% at the end.
Friend, no, we was always maybe he is best. But you see, the truth of the matter is say NDC people who were charged, the lawyers that were involved, they happen to be the Attorney General or people working in the Attorney General's former office, the Deputy Attorney General or Deputy Attorney General's former office. Now they find themselves in government. They are going after their former clients, which is what we call conflict of interest. You are not allowed to go after your former clients. So they are in a difficult position. Say, how do I now represent the state against my clients? And Untina, almost find a way to make all the cases flesh cases. You know, almost continuing cases, because you are not allowed to go after your former clients. And Dr. Adofo, all the other ones, they were represented by either the Attorney General himself or their office.
You can't go after your former client.
Correct. That is the position of the law. It's like me now, Kwame, we are a client. I cannot in the future go after you.
Me no case be and I similar no behind.
I'm not allowed.
Oh wow.
That is why. They find themselves in a conflict of interest. So they need to find a way to overcome that conflict. And that's the truth.
I see. No.
You know, Attorney General. And I will Kwame, who is my former client. Why I'm not allowed to touch your case? Because you've been in a position before. I was confiding in me. I know all your vulnerabilities.
Yes, I know the evidence. Okay.
I know all your vulnerabilities. So, Pamno, don't go after your former client.
Wow.
I don't know. One more final one, someone said they are in conflict. And on my head, they drop those charges, finding flimsy excuses which hold no water. Yes, I call you and say, I said, refer those cases are one more than in Sakano. Emma special prosecutor, because that's what the law says. And this one is important. He's a special prosecutor. He's not on his own. And people are mistaking the special prosecutor independent. No, they are wrong. The act says he can only act when he is authorized by the Attorney General or Parliament. Authorized by the Attorney General or Parliament. But once he has to be challenged.
Baba, there were other subsidiary legislation. I
don't understand.
Sir, there were other acts be a Parliament a pass it. Special prosecutor. Say I am rather batana.
Yes.
Aha. I was a special prosecutor. Operations Regulations 2018 LI 2374. Yeah. If you want to mean them, I'm finding a without recourse to the Attorney General.
And to say what? You have to go back to Attorney General for authorization.
Oh wow.
Because in the airline, simply about procedure, how to go about things. But you have to be authorized. Well, no, Attorney General. Finding himself in conflict, the essay or refer those cases to the special prosecutor as an independent person to take over. That's what they are here. That's what the Attorney General ought to have done. It will be someone to overcome that, and he's not prepared to give it to the office of Attorney General. They are on discontinued cases. Now, they will say, we just at home. That's, this is what we follow. And a man who's a Ghana, you need that to be a.
Mati. Lord, Mamma, now was not missing your pamphlet.
Thank you.
Mr. Medasipa. Kwame Adofo Esquire. We're a private legal practitioner and you're not trying to communicate 101.7. So, any
okayfm 101.7.